give a warm pachyderm welcome to our speaker today, former state representative Steve Brunk.
Thank you, Carl. I think I did tell you it was 2003 through 2014, and as I sat down, I know it was 2016, so it was about a decade and a half. And so that was a real good season in my life. I had the real privilege. I'm very, very much pro-life, as I'm assuming that the majority of you are in here. So that was kind of an impetus for me to be able to run in the first place. And so it was a real privilege for me to be able ultimately to chair federal and state affairs. And Leo, at that time, all of the kind of hot button issues did go through federal and state affairs. I mean, we had all the Second Amendment things. We were able to pass constitutional carry, right to carry, a number of things regarding the Second Amendment, all of the pro-life legislation. After Governor, actually while Sebelius was there, we were able to get certain things through. Alexa's law, we did that. There was a number of other pieces of legislation that we were able to get through despite her. When Sam came in, Governor Brownback, he said, "You put a pro-life piece of legislation on my desk and we'll sign it." And he was true to his word. So we were able to accomplish quite a bit during those times. One of them was, it was a ban. Well, I'll get into that later. And so anyway, quite a privilege in order to be able to be there. And so we appreciate it very much. Carl indicated that he had tried his best in order to be able to get somebody here that could talk about the bond issue on the other side, the proponents of the bond issue. And so if you don't mind, now that I have the mic, and you didn't have them here, I'll just fill in for them. So you've heard from the no side, and they were really articulate and gave some good reasons why we should oppose the bond issue. So I think it's only fair that someone should speak for the proponent side. And so I think here's their argument. More. More. Well, no, how much? Well, more. Well, what do you need it for? Well, because we need more. And so, so I'm glad to be able to fill in. And so I hope you're all as enlightened now as I am. So throughout the course of our human existence, there have been events that have changed the flow of human history. Some of them are of biblical proportions. The fall of man, the flood, the Tower of Babel, and the initiation of languages. Moses crossed the sea to establish a new nation. In my own faith, the Son of God died as a sacrifice for sins, allowing for the redemption of mankind. It changed the course, changed the flow of human history, specific events. In our own country, the Declaration of Independence from a tyrannical king set in motion a sequence of events that gave men their freedom and birthed a new nation. It liberated people. We fought wars to protect freedoms and again to liberate other peoples and nations that had fallen to tyrants, dictators, and oppressors. Other events have changed the course of history. I'm not used to doing this. When I stand back here, can you hear me in the back row? Kevin, can you hear me? Thank you. Thank you for playing. I appreciate it. So, yeah, so if I can't, if I veer away from this, occasionally I need adult supervision. And so if one of you guys on the back row would just wave your hand or do this. So thank you. I'll try to remember to kind of stay in close to this thing. So while other events have changed our human history for all sometimes evil, not necessarily good, and again, keeping kind of with this religious theme that I've started off with, Americans stopped calling on the name of the Lord. Our churches have lost authority as the conscience of the nation. Our education system has gone from education to indoctrination, and our Supreme Court of the federals has kicked God, prayer, and the Ten Commandments out of the classroom, events that have triggered a downward spiral over time. So by example, we've talked about this, maybe talk about it more, the Supreme Court in Roe v. Wade discovered a right to abortion in our Kansas Constitution, initiating 5 decades of abortion and the death of 60 million plus innocent babies, our own national Holocaust. And so some specific events trigger other events then that change the course of human history. So let me bring that down a little bit. In our own state and city, Kansas was initiated. We saw Bleeding Kansas have our state join in the nation as a free state, rejecting slavery and oppression. Kansas became famous for Brown versus the Board of Education, the Dockham sit-in, and more recently in 1991, not necessarily recently, but in 1991, we had the Summer of Mercy right here in Wichita. That was an event that kind of changed the course or changed the flow of history and events that surrounded what happens here in Wichita, Kansas. Sometimes a natural event can cause a course change. The Greensburg tornado, right? The Andover tornado kind of marked time. Where were you at the Andover tornado? People remember that. We went out to the Andover tornado site after it happened, and it was just, I'd never seen that kind of destruction. You see it on TV. You see the pictures of the fires that ravaged Southern California, but to actually be there, it's quite something else. And so sometimes a natural event like that can cause a change or a course flow in events in human history. Sometimes events are personal and change the course of your own life personally. It's certainly true in my case. Our first child, our daughter, was born with a spina bifida. It's a congenital birth defect. So as young parents without insurance, I'm recalling now at the time, young parents without insurance, that changed the course of our marriage, changed the course of our life. We started the Spina Bifida Association of Kansas. We started a brace fund. We raised money to send new parents to the National Spina Bifida conferences. Without that event, that course change in our life, we would never have gone down that particular path. And so now that I think I've probably overstated this in my opening, there are certain events that can happen naturally or not that change the course or change the flow of human history, and that's certainly true in Kansas. And so I said all of that then to say this: there is an event in our own state history that has changed the trajectory of our state. It's a little known event, but has had great impact on the lives of Kansas. Of course, I'm referring to, as the introduction was, to the events that led to the change in our state constitution, allowing for this nominating commission of the Kansas court. So here's a question. Did you know, and I know you already do, since Carl now gave about half of my speech in the introduction. Thank you, Carl. Did you know that the Supreme Court is controlled by the Kansas bar? I'm sure most of you do. And that we, the people, are eliminated from the selection process. It's true. In our own Constitution, the Kansas Bill of Rights clearly states and you know this, all political power is inherent in the people, and all free governments are founded on their authority. But in the Supreme Court selection process is controlled by a nominating commission, which is controlled by the Kansas bar, with no connection to we the people. So this is an absolute contradiction in our Constitution about the authority of we the people, when we the people have zero connection to the nominating commission that is controlled by the Bar Association, that controls the highest court in our state. So how exactly did we get to this place? Again, it's kind of a long and relatively unknown story. At one time, Kansas enjoyed direct elections of our Supreme Court justices, just like other branches of our government. They, like other officials, were accountable to we the people. But in 1957, that all changed with the infamous political triple play. This is not the KC Royals, but this is a political triple play. So do you all know about the triple play and what happened? Can you just show me? Oh, good. I just assumed that everybody would. Well, I can continue then. So the political triple play. Governor Fred Hall was a young so-called firebrand politician. He was 30-something, had just lost his election bid to retain his governorship. His political allies of those days wanted to keep their influence alive in the state, so they concocted a lame duck scheme, to keep Hall politically viable. So after he was unelected and before the new governor, Docking, was sworn in, the triple play unfolded. And so here's how the scheme occurred. Supreme Court Justice William Smith, 69, retired from the court for health reasons. Kidney stones, massive kidney stones. He was in the hospital. It was a legit retirement. So at that time, that was a far more difficult thing to endure than it is now. But he retired. He was asked to retire. He was part of this plan and did so. So he retired from the court for health reasons. Outgoing Governor Hall now retired from his position as governor, temporarily elevating Lieutenant Governor John McEwish to the governorship. So now new Governor John McEwish then appointed previous Governor Hall to the Supreme Court, filling the vacancy left by the now retired William Smith. So this triple play took approximately 15 minutes to accomplish on January 3rd in 1957. And so three things happened that kind of changed the course, changed the flow of history here in the state of Kansas. So all of this happened over the holidays, and the public reaction, as you can imagine, was intense. That their hope that these job switches would go unnoticed during the holidays. They couldn't have been more wrong. The public rightly reacted with outrage, demanding a change to prevent this kind of political trickery from happening again. So again, the Supreme Court justices at that time were directly elected by the public. So the only necessary change they would have needed to make was a change in how you fill a vacancy. So the election process was fine, but they completely overreacted, the legislature and the public, opting instead to change the entire nature of the Kansas Supreme Court. So enter now this nominating commission. They changed the Kansas Constitution to eliminate Supreme Court direct elections and instead established a nominating commission comprised of nine individuals. Those individuals have the authority to select 3 names and provide those 3 names to the current governor anytime a Supreme Court vacancy occurs. So if the governor then fails to select one of those 3 names, the Chief Justice of the court then has the constitutional right and authority to make that appointment himself or herself. So the appointments to the highest court in Kansas would now be made by this nominating commission, not Kansas citizens. So the question then begs the question, who gets to be on this powerful, unaccountable nominating commission? So if it wasn't grievous enough to take the power of selecting the court away from the citizens, this 9-member commission is made up by the governor appointing 4 members, with the remaining 5 members, a majority, all appointed by the Kansas bar. So no offense to any attorneys in the House there, none whatsoever. However, we do find that that is a grievous situation, because now instead of this court being elected by citizens, this 9-member commission is made up again by the governor appointing members with the remaining members, a majority, all appointed by the Kansas bar. So let that soak in for a minute. And so instead of citizens across the state, now lawyers, one profession, get to choose who picks the justices for the Kansas's highest court. So our Kansas reality now, since that happened in the triple play was in 1957, this occurred in 1958. Kansas is the only state which has a Supreme Court nominating commission with the majority of its members who are lawyers, elected by the rest of the bar. So in other words, we're the only state in which one profession, lawyers, has absolute control over the membership of the highest court in state government. So out of approximately 8,000 members in the Kansas bar, when I looked it up, I saw 7,945, 7,800. Stephen Ware said that there was about 10,000. So out of about 8,000 members, there's a 20 to 25% participation rate amongst attorneys voting to establish the nominating commission's members. So with the commission appointments being primarily dominated by large trial attorney corporations, it is no wonder that a liberal bias has pervaded our Supreme Court for decades. They predominantly have a homogeneous thought process, much more willing to view the Constitution as a living document that can and must be reinterpreted to fit the times. That's where we are today with this particular Supreme Court. So as was mentioned, KU Professor Stephen Ware has been here before. He also testified before the Kansas legislature. And he submitted testimony saying that after reviewing the mechanism for all 50 states, how the Supreme Court justices are selected, appointed, elected, he discovered that Kansas Supreme Court selection process, he says, is undemocratic, extreme, and secretive. So his testimony then elaborated on those three issues. Undemocratic, where states, no one can become a justice in the Kansas Supreme Court without being one of three finalists chosen by the Kansas Supreme Court Nominating Commission. The commission is the gatekeeper to the Kansas Supreme Court. However, the commission is selected in a shockingly undemocratic way. He goes on to say, most of the members of the commission are picked in elections open to only about 8,000 people, the members of the state bar. The remaining 2.9 million, 3 million people in the state of Kansas have no vote, have no voice in these elections. He continues, this violates basic equality among citizens, the principle of one person, one vote. The current system concentrates tremendous power in one small group and treats everyone else like second-class citizens. In a democracy, a lawyer's vote should not be worth more than any other citizen's vote, according to Stephen Ware, and I would wholeheartedly agree. There's a professor of law at Washburn, Jeffrey Jackson, who wrote, democratic legitimacy, to make this process legitimate for a democracy, would appear to favor a reduction in the influence of the state bar and the members over the nominating commission because they do not fit within the democratic process. That's our situation today. He also calls this selection process extreme. I had a chart. It's blurry. I'm just going to say what it is. So out of the 50 states, where has on this side a state that has really high bar control for the nominating commission, and on this side, very low or no control by any bar association. So Kansas is the sole state where the commission has a majority selected by the bar. Kansas is the only one. There are 8 other states that do have some membership, some participation by their bar, but they are a minority or they are very, very limited in their ability to be able to control that. Nominating commission with little or nothing for the bar. They do have nominating commissions, but there's 3 states that have nominating commissions. They're appointed in the general way that commissions get appointed. The governor gets to select some, the president of the Senate gets to select some, the House leaders get to select some Republicans get to select some, Democrats get to select some. And so only 3 states have that mechanism. By far, the majority of the states either have the federal model where the president appoints and the Senate confirms, or the governor appoints and the Senate confirms. 14 states have that, and then in conjunction with that, 15 states have nonpartisan direct elections, and 7 states have partisan direct elections. So 14, 15, 29, and 7, 36 of our states have some mechanism for selecting the Supreme Court justices that is open directly to we the people instead of some kind of nominating commission. And again, Kansas is the only state in the nation that has such a mechanism where the bar controls the nominating commission. So he calls us extreme, and again, I would agree. He also says that it's secret, where it goes on to say, the process for selecting Kansas Supreme Court justices is not only undemocratic, but also secretive. Not only does the bar currently exercise a tremendous amount of power, but also that power has been exercised behind closed doors because the Kansas Supreme Court Nominating Commission's votes have been secret. This lack of a public record of who voted which way has prevented journalists and other citizens from learning about crucial decisions in the selection of our highest judges. There was a correction that tried to be made in 2006. The legislature passed a law that said that they are a public body, and so therefore they're open for open state records. However, the Kansas Court's Office of Judicial Administration, a mouthful, they put out a news release that says the commission's interviews are open to the public, but does not say that the commission's votes will be public and recorded. So we cannot be confident that the secrecy problem of the Kansas Supreme Court process has been fixed. So a need to change. The Kansas Supreme Court will never be accountable for their decisions, and most importantly, it will never represent Kansans or their values under this current selection scheme. So what will it take to change? The only mechanism available to us for we the people is a constitutional amendment. So it starts with the Kansas legislature. Thank you. Appreciate that. I'll come in here and try to get closer. Okay, it starts with the Kansas legislature. I've had other people up here, they get up so close that the microphone does that. So again, I'm not practiced at this, so you'll forgive me before we go any further. So a constitutional amendment is the only mechanism that we the people have to be able to change this. They must introduce a concurrent resolution stating that a resolution that is going to be voted on by the Senate and the House, concurrent. It's a resolution we concurrently resolve that and state the language to be amended into the Constitution, provide an explanation for the voters to read, and set a date for the citizens to vote. So it must pass with a 2/3 majority in the House and the Senate, and then must pass by a simple majority of the voters to make that change. So we might ask, so what's the big deal? What's the big deal? Aren't these people elected on a merit basis, supposedly? Aren't these people supposed to have the highest intentions, and they're not going to be influenced at all by any kind of politics? They're not going to be influenced by any kind of worldview. Why do we need to make this change? Good question. So if they were making righteous decisions and interpreted the laws from the Constitution, we wouldn't be talking about this, but they don't and they aren't. And so there are a number of instances that I could cite. I'm going to cite 4 things that this particular court has done that I think are egregious, that would give us pause, and that should give us reasons to say, yeah, they're not acting in a manner that is in a righteous way. They're not acting in an unpolitical way. They are not acting with the state's citizens of this state's best interest. They are acting according to their own worldview. So number 1, the Kansas Supreme Court justices make law. Here's a statement from, again, the Kansas Court's Office of Judicial Administration news release. This is their statement saying, "Isn't it true that justices must follow the law and not be influenced by politics, special interest groups, public opinion, or their own personal beliefs?" No, that statement is misleading. That's their own statement, that it's misleading to say that they should be independent. A clear case of lawmaking by the Kansas Supreme Court is a work comp case, Coleman versus Armour Swift. As the court's opinion by Justice Beyer explained, the pertinent facts are simple and undisputed. While waiting for the start of a meeting required by her employer, Armour Swift, Mrs. Coleman, sat on a chair that had rollers on it, propped her feet up on another chair. A coworker came up behind Coleman, took hold of the back of the chair, dumped her out of it and onto the floor. The fall injured her back. No ill will between Coleman and her coworker, and Coleman had done nothing to provoke or encourage him. There was no evidence that such horseplay was common at Armour or that the company had in some way condoned this co-worker's actions. So the question then, was Coleman entitled to workers' compensation? Not under existing law at that time, as it stood at the time of this 2006 case. So Coleman would clearly lose this case if judges always merely follow the law. Under this, and this is Justice Beyer's words, under this unrealistically narrow description of judging, the Coleman case would end in a simple ruling for the defendant. If judges do not engage in lawmaking, then Coleman would clearly lose this case. And as Justice Beyer continues, the rule is clear. Any injury from the horseplay does not arise out of employment and is not compensable unless the employer was aware of this activity or it had become the habit of the workplace. So, however, Justice Beyer and her colleagues on the Kansas Supreme Court did, in fact, engage in lawmaking. Justice Beyer's opinion doing this started by criticizing the old rule, the old law, while acknowledging that it was, in fact, the rule, the law, prior to her opinion by which the Supreme Court made new law. And so the actual quote from her is a little different. The rule is clear if a bit decrepit and unpopular. Emphasize those words that were left out before. The rule is clear. The previous law regarding work comp, man, we're in the weeds. I'm sorry about this. Half the room's going, check, please. But in her own words, this rule, the previous law, should have been in place, but it was decrepit and unpopular. An injury from horseplay does not arise out of employment and is not compensable unless the employer was aware of the activity or it had become a habit of the workplace. So who decides that this rule, this law, is decrepit and unpopular and so should be changed? Was it the Kansas legislature that is tasked with making law? No. In this case, it was the Kansas Supreme Court. It was judges, not legislators, who decided that this legal rule was bad policy and who changed the law to bring it in line with what lawmaking judges thought was good policy. Justice Breyer candidly stated, Coleman cannot prevail on this appeal unless we are willing to do now what this court previously was unwilling to do. Reevaluate the wisdom of the horseplay rule. Years later, we think it's time to do so. And so here we have, cut to the chase here, you have a court that made law. Rather than interpreting what was the existing law, they just simply reinterpreted and changed it. Work comp law at that time said that Coleman should not have been compensated in work comp and that the defendant, the company, shouldn't have to pay this. But the judges simply, on their own authority, based on their old worldview, decided that it was decrepit and unpopular and changed it. And so one case where they've actually just made law. So here's the point. If they, by their own words, saying that it is incumbent upon them to make law and change law that is decrepit and unpopular, if they're going to be lawmakers, shouldn't we be electing them instead of appointing them through the nominating commission? Shouldn't they be elected by we the people? We elect our lawmakers, and they have accountability back to we the people if they openly admit that this is their position. My position is that we should be electing them, not appointing them by an unelected bar. Number two, Senate Bill 66. And so prior to 2007, the Kansas Constitution specifically prohibited gambling in Kansas, but did specifically allow for a lottery to be owned and operated by the state of Kansas. It was generally understood that a lottery was a way for nonprofits to raise money, for example, at a local VFW. But Senate Bill 66 changed all of that. The Supreme Court ruled that a lottery was really gambling, and so if it was really gambling, then any other form of gambling was just like a lottery. Kathleen Sebelius was governor at that time, desperately wanted gambling in Kansas, and was working with the court to reinterpret the language. Senate Bill 66 was the result. So this is not about whether you like gambling in Kansas or don't like gambling in Kansas. The Constitution said no gambling in the state of Kansas. That was reinterpreted. In the bill, Senate Bill 66, which is multiple pages front and back in tiny little letters that I can barely see or read. I had to blow it up in order to be able to read it. So Senate Bill 66, and changing definitions of words, and Bill Section 1.A, first thing up. Ancillary lottery operations, that's what it was previously. It was a lottery operation, really means additional non-lottery facility game products and services not owned and operated by the state, which may be included in the overall development associated with lottery gaming facility. Such operations may include, but are not limited to, restaurants, hotels, motels, museums, or entertainment facilities. So they took what was very narrowly in our Constitution to allow only for a lottery and expanded that into just full-blown gambling/gaming. So again, they just changed the meaning of the word, changed the definition. They simply redefined the language to mean the opposite of what the original language really intended. And so to keep it state-owned, they invented a lottery gaming facility manager employed by the state. So again, whether you are for or against the gambling isn't the point. The point is that this particular court felt it incumbent upon themselves just simply to redefine the language to get what they wanted. Sebelius's chief of staff at that time was the wife of the Supreme Court justices that was heavily involved in this, and so no conflict there, no conflict there. He said with as much sarcasm as he could muster. School finance, number 3, school finance. Article 6 under education, point 6b says the legislature shall make suitable provision for finance of educational interest of the state. No tuition shall be charged for attendance at any public school to pupils required by law to attend such school, except such fees or supplemental charges may be authorized by the state. So who gets to decide how much school finance, according to our Constitution, goes into school finance? The legislature shall make suitable provisions for finance. It's the legislature that controls the purse, not the Supreme Court. So there was the Montoy case where the state was sued. Then on its heels came the Gannon case. It was based on school cuts that were actually made by Mark Parkinson, who succeeded Sebelius for one term. When Sebelius got appointed to go be Barack Obama's Secretary of Health and Human Services, Mark Parkinson then succeeded her. He was there for one term. And so we are in the middle of a recession then. Monies came in, didn't come in, to the point where we were scrambling to figure out how to pay the bills. And so Mark was kind of forced, since school finance was the last thing that was cut, school finance then, he just made little cut. And so we were sued. We were sued by Gannon. So to make this long story short, ultimately the Supreme Court told the legislature to authorize a certain number of dollars for education by a certain date. That's not the Supreme Court's role, to say, legislature, you must authorize this amount of money by that amount of date. Can you imagine that happening at the federal level? If our Supreme Court came in and told the House or the Senate, you must finance this, and you must finance it by this date, and you must finance it by this amount of dollars. The legislature would recoil at that. I was trying to think of some word that I could say that wouldn't destroy my my church attendance rule. So I was failing in that. And so rightly at that time, the Kansas legislature and the Kansas Supreme Court, I mean, we were butting heads. And so the Supreme Court kept this case alive until 2023, I believe. I think it was just last year where they finally released it. It started in 2010. So they held on to this for 13 years. And so, again, this point isn't whether you think there's enough money in education. It's that this court took an activist position and encroached on the legislature's constitutional territory. So under our current Supreme Court selection scheme, they are accountable to nobody. The last one, which probably in my mind is the most egregious. I talked about being pro-life here. I'm guessing that the majority of you here probably are too, to some degree or another. And so Kansas, so it's abortion. You know the story. The abortionists sued the state of Kansas over a particular bill known as a ban on dismemberment abortions. The bill banned abortions in a late term of pregnancy, banned abortionists in a late-term pregnancy from reaching in with tools to rip off an arm, rip off another arm, then the legs, crush the head, and deliver a dead baby. It was a brutal and horrific procedure. They sued. So a district court judge ruled for them and against the law. It went to the Court of Appeals, where there was a 7-7 tie, couldn't overturn it. Failing to overturn this district court judge, that sent it to the Supreme Court, which agreed with the ruling. The ruling discovered a right to an abortion in the Kansas Constitution, and you all have followed this. You know that they just made this up out of thin air. There is no right to an abortion in the Kansas Constitution. In 1860-something, when Kansas became a state, it was actually against the law to have an abortion at that time. No way would the framers of our Constitution have put that into the Constitution. But this Supreme Court found in life, liberty, and the pursuit of happiness, found that there was a right to an abortion in the Kansas Constitution. So Kansas has become extreme. In 2019, Kansas was one of the most pro-life states in the nation, but became an abortion destination state. This designation was only enhanced more when in 2022, Roe v. Wade, Roe v. Wade was overturned by the U.S. Supreme Court, returning abortion regulation back to each of the 50 states. That should have been a cause for celebration, but not in Kansas. Kansas is one of the most extreme states for allowing abortion access. In 2019, we had 6,916 abortions, a horrific number in my opinion, for sure. However, in 2022, that number skyrocketed to 12,318, nearly doubling in 2024. Over 20,000 plus abortions will occur in Kansas. Let that sink in for a moment. 20,000 lives plus ended before they ever take their first breath right here in Kansas. That's about 77 abortions per week, Monday through Friday, excluding Saturday and Sunday on an 8 to 5 workday. So if you add up all the abortions that have been officially reported by the abortion industry itself, since Kansas began tracking this awful statistic in 1978, been approximately 471,900 abortions have occurred in Kansas. What an impact that has had now. Put that in a different perspective, someone born in 1978 would likely now be married, have a home, several children in 2024, maybe grandchildren as well. Assuming a modestly sized household, the math tells us that if the 780 babies aborted in 1978 were with us today, we would have 39,120 more people. The original number plus his or her 2 grandchildren and 1 grandchildren, all of which would contribute to the economy, holding jobs, owning properties, sending kids to school, attending church, the list goes on, and that's just for the year 1978. And so while the public, the citizens of Kansas, elected individuals to control the amount of abortions that we have in the state of Kansas, the Kansas Supreme Court said, all bets off. Now it's wide open. We told them at the time that that was going to increase. Kansas would become an abortion destination state, and that's exactly what happened. So let me skip on over here. I didn't really mean to make this about abortion, but that's really personal to me. That particular bill, the ban on dismembered abortion was my bill. I carried it through my committee. I got it voted through my committee. I worked it over into the Senate. We got it through on the Senate, got it through out on the House floor. I carried the bill on the House floor, followed it over in the Senate. Sam signed it into law, and that's the bill that they used to overturn our abortion laws in the state of Kansas. So it got real personal to me real quick. So didn't mean to make it about that. So 4 instances, you were here last week, you brought up, what about the death penalty? We were talking about the Carr brothers, right? And so Kansas has the death penalty until the Supreme Court decided that we didn't. And so they were overturned by the federal Supreme Court. In fact, our Kansas Supreme Court is one of the most overturned courts in the country. And this is not by this recent court. This was a pre-Trump court that had a very, very liberal bias. They were, oh no, Kansas, you're too much for us. You're too liberal for us. Kansas, you've gone too far. So they've been overturned numerous times by the federal Supreme Court. So here we are. What to do now? So we have no longer direct elections. we should be enjoying direct elections, but we don't. So enter bill concurrent resolution now, Leo, Senate concurrent resolution 1611. There's a hearing in Senate Fed and State Affairs this Tuesday, that provides for direct elections of the Kansas Supreme Court. It also says that it's going to be partisan. It's partisan elections, which I think is a mistake. I think it just makes it too easy for the other side to attack. I wish they would be politically agnostic on this. And so it does provide for direct elections. It says that the justices will be staggered out, and that those direct elections, we're going to vote on that in 2026 at the next general election. So I'm going up to say, I'm going to go testify. I've already sent my testimony in and say, yes, we agree in direct elections. I want to disagree with them about the partisan nature of it. I think that makes it too easy to attack. I'm looking at opinion articles in newspapers around the state. They are already attacking it. Those rascally Republicans, they just want to take authority away from the Supreme Court. Those wonderful people that are elected on merit, who have the highest integrity and honor. No, not really, not really. And so they're already marketing it. So anyway, I would ask them to be politically agnostic and make this a nonpartisan election. The other thing that it allows for, it says that the mechanism for replacing a Supreme Court judge is still direct elections, but if there is a vacancy, then they are to be elected at the next general election. And so I had a question: what happens if somebody dies? What happens if somebody resigns and it's a day before the next general election? What if it's a week before? What if it's a month before? So they've not made any mechanism available for a vacancy occurring. And so I think they need to amend that. So anyway, going to go up and testify. The opportunity is there for citizens to chime in. It's next Tuesday in the Senate Federal and State Affairs Committee to get this changed. And so the ball has started rolling. But we need a massive, massive education process throughout the state of Kansas. Most people have no idea that our Supreme Court justices are appointed by the Bar Association, and that we, the citizens, have zero connection to that. We've been completely left out of this process. So we have to educate them about why this is necessary to make this change, how it happened that we got to this point in the first place, and then after that, we have to educate them that, yes, this is the right mechanism to be able to accomplish this. So the other side, all they have to do is just throw things up against the wall. Well, you're going to lose your rights. Well, it's really all about abortion. Well, it's really about those Republicans that are just trying to gain control. Well, it's really just about the legislature trying to encroach on the judicial branch. And so if any of that stick, people will, I'm not sure, they just vote no, and we'll lose this. So it's going to require massive education amounts. So that process is getting started and is underway. So I'm using you all as a guinea pig. I'm going to be traveling around talking about this. You're the first ones. So I've got to learn here what to cut out, what to add in. Do I put in slides? What do we do? What do we do? So you all are my guinea pigs. I apologize for that. So I'm just testing this out on you. So at this point, I'm just going to open it up for questions.
Okay, thanks, Steve. And so if you're a member, keep your hands high. We'll start with members and try to get as many questions as we can in still today. We'll start right up there.
Yeah, what's wrong with the federal model?
Nothing in my mind. They're two really good models. The federal model, where the governor would appoint and the Senate would confirm. The legislature ran that a few years ago and was unsuccessful in getting it done. The reason they're going to direct elections now is it's been poll tested, and the polls come back hugely in favor of direct elections. And also particularly then if our point is that we, the people, have been left out of the process, then the best mechanism for we, the people, would be to directly elect like we did before. If they did indirect authority by we, the people, where we elect our senators, where we elect a governor, at least we still have some skin in the game. The current mechanism, we have none. So I'd be fine with that model. That's not the one that they've teed up.
Steve, over here on the back.
Do we not have a retention vote on the Supreme Court justices every couple of years? Why aren't we using that mechanism to remove them?
We've tried that. So no justice has ever been not retained, and you're right. Every 6 years shall justice so-and-so be retained. We've mounted campaigns to try to do that, and we've never been successful in doing that. And then the problem is, let's say we are successful. And so what's the mechanism for electing a Supreme Court justice? It goes right back to the bar, and then you get the same worldview, you get the same person or worse that you've just unretained. And so the mechanism for after the retention vote, if you're successful, it's the same mechanism. So you're going to get the same worldview, homogeneous thought process right back in.
Okay, Steve.
Dave, thanks for coming. Good job. Appreciate what you're doing. Do we have the 2/3 we need in the House and the Senate to get it passed?
Pretty sure, yeah. We didn't before this previous election. Elections do matter. So for those of you that gave money, that knocked on doors, that voted for your particular representative, some of our stinkers, even in the Republican Party, have been ousted. And so now we do believe that we have a solid, Leo, you could probably help me with that. Do you think we have a 2/3 majority in the House and the Senate? I'm convinced that we do.
This past week proved that we have typically 87 House Republicans vote to help overturn vetoes and pass legislation. On the Senate, we had 31. That's well within the 2/3 vote.
And thank you very much. Recently, the governor's veto on help not harm, voting to disallow transgender surgeries. Kansas said, we don't want that in Kansas. We don't want that in Kansas. And the legislature passed it. The governor, yeah, thank you, Leo. They passed it last year. The governor vetoed it. And so some of those people in the Republican Party and the Democrat Party that voted to follow the governor are polishing up the resume, looking for other employment right now. And so we were successful this year then in overturning that. So thank you very much.
Okay, Steve, over here.
Hi there. I'm relatively new to Kansas. I've been here a little over a year. And pro-life, abortion, that's kind of like my hot button issue as well. I've traveled the entire country fighting it. What exactly was the logic behind changing the death penalty, but also changing abortion? Because in my mind, I tell people I'm anti-abortion because I support the death penalty. If I find a pedophile doing something to a child, I'm going to shoot him. End of story. So when it comes to an innocent baby, what was their logic exactly that we're going to support these wicked, evil people and letting them live, but we're going to rip apart the innocent babies?
It's upside down, isn't it? And so on one hand, they said, oh no, the death penalty, cruel and unusual punishment. We can't do that. But we're going to sentence living human beings, albeit yet not born, unborn, but still living human beings. We're going to sentence them to death by egregious methods. Yeah, so they're upside down. So in my mind, I've had people ask, well, how can you be for the death penalty but be pro-life? Two different issues. The child in the mother's womb has committed no crime. This is an innocent person. The person, like, who can we use that everybody, Carr Brothers. Carr Brothers. If you've been, you don't know the Carr Brothers, but if you've been around here for a while, you know the Carr Brothers. If there was ever any two people that deserve the death penalty, man, they're right up there at the top of my list. So they've got it upside down. They want to punish innocent children in the womb, but not punish to the fullest extent criminals.
Okay, one last question, James.
Which is another reason why I think we need to change our Supreme Court selection process. Because if they were making righteous decisions, we wouldn't be talking about this.
Yeah, I don't believe there's three equal branches of government. To me, the legislature is the will of the people. They make the laws, and the president or governor is supposed to enforce those laws, and the judges are supposed to resolve disputes by interpreting. So, that being the case, if judges have misinterpreted the Constitution, why can't the legislature clarify the law and therefore overrule the judges?
Because the Constitution is a higher authority than any state law. And so when they have reinterpreted the Constitution, then it becomes in the Constitution, and no state law can override the Constitution. That's why we've got to go with a constitutional amendment. That's why we tried value them both. After they made this change and decided that there was a right to an abortion in the Kansas Constitution, the legislature, rightfully so, tried to say, well, let's change the Constitution then and say that all of these matters should be decided by the people through their elected representatives, the legislature. And we lost the marketing campaign on that, and it was voted down, and so here we are. And so now, instead of 6,916 abortions in the state of Kansas, we're at 20,000 and climbing per year.
Good job.